Okay, everybody, let's dive into Nevada bar prep. We're going to go into the Nevada distinctions of criminal law. Okay, we're first going to go through theft crimes, then the following video we'll go through homicide, and then we'll dive into criminal procedure. And believe you me, it's not that bad. It's very similar to the majority rule and common law. However, there are some distinctions that we have to note here. So let's finally go through Nevada theft crimes one step at a time. So our outline here, we'll go through petit larceny, grand larceny, embezzlement, false pretenses, robbery, burglary, home invasion, and receiving stolen property. And after that, we'll finally conclude the video. Okay. A lot of crimes here, a lot of elements to memorize, but again, it's really not that bad. It's gonna be very similar to the majority rule. Okay. And to keep in mind, these are not general intent crimes because under Nevada law, all theft crimes are specific to crimes except for robbery because robbery is a general intent crime. Okay. Again, we'll go through this in a second. So first, let's finally dive into grand larceny. Grand larceny is the intentional theft of personal property, basically tangible, immovable property with a value of $1,200 or more. So if the defendant steals property that has a value of $1,200 or more, he or she will be liable for grand larceny. And another way for the defendant to be liable for this crime is not simply taking property, movable, tangible property of another, like their cell phone or their TV set, but a defendant can be liable for grand larceny through the use of someone else's debit or credit cards, or even stealing the other person's animals or birds. So again, let's say that the victim has five huskies, five husky puppies, let's say, that are worth a lot of money. Okay, we all know puppies can be pretty expensive, especially huskies and German shepherds, right, with certain bloodlines. And let's say that they are well over $1,200. That could be a way for the defendant to be liable for grand larceny, and that'll satisfy the element of this crime. Another key example here that I want to explain is that let's just say that Kenzie walks into a Walmart. Let's say the woman in this picture is Mackenzie holding the cart. There's a lot of tangible, movable chattels in the cart, and she places five PlayStation 5s into the cart. She doesn't pay. She walks out of Walmart and then goes home. We all know PlayStation 5s has a value of $500 or more in this market, as we know. So stealing five of them will clearly be well over our required amount of $1,200, and she could be liable for grand larceny. Petit larceny, very straightforward. It's the same definition as grand larceny. However, the only distinction is that petit larceny is stolen property that is worth less than $1,200. So again, if the property stolen by the defendant is less than $1,200, it will be petit larceny rather than grand larceny. So the amount of money in regards to petit and grand larceny is very critical to understand when you're looking at your fact pattern or just thinking about theft in general. If it's more than that amount of money, it'll be grand. If it's less than, it'll be petit. Excuse me. So again, same example as above with Mackenzie, except let's say she steals one PlayStation 5 rather than five PlayStation 5s. As we know, one PlayStation 5 is $500, right? She steals five, it's well over $1,200. But in this case, she steals only one. She gets caught, she'll be liable for petit larceny rather than grand larceny. Embezzlement. Embezzlement is an interesting crime, in my personal opinion. So let's go through the elements of the definition. Any bailee of any money or property who converts it into his or her own use with the intent to steal it or defraud the owner. You probably thinking to yourself, what the heck does that mean? This sounds like Japanese, right? Let's explain exactly what that sentence means. This statement means that the bailee, let's say a cashier, and the bailor, the customer, is at Walmart. Okay. You want to buy a Nintendo Switch. That's $300. Okay. You give the Bailey, the cashier, the money to buy the Nintendo Switch. And the Bailey, the cashier, has a duty to put that money in the register, not their own pocket. Embezzlement means that the cashier does not put the money into the register, but they put it into their own pocket. They use that money, they convert that money into their own personal use with the intent to steal that money and to defraud the owner of that money, the customer. That is an example of the cashier being liable for embezzlement because they used that money that they were entrusted with by the customer and they put it in their own pocket instead of putting it into the register as required due to their duties as a cashier at Walmart. The second sentence is very similar here. Let's look at the second statement that's on the PowerPoint here. A person entrusted with money, let's say a cashier, or property, let's say you are valet parking and you give your car to the valet, right? That person, the valet guy, uses it for their own personal use rather than using it to park your car and wait for your return to get your car back. They use that car for their own personal use and drive away, let's say. That is an example of the valet guy being liable for embezzlement because they used that car that you entrusted to them for their own personal gain rather than simply parking your car and giving it back to you when you return from dinner. Another example, this is that Eric deposits his $10,000 paycheck into his bank account. Let's say he goes to US Bank. He has his check in his hand. He goes to US Bank. He deposits that money into his personal bank account. However, the bank teller, let's say this lady in this photo, deposits $9,000 into Eric's bank account, but she puts the extra $1,000 into her own purse. That is an example of embezzlement because she's using the money that's entrusted to her by Eric into her own personal use. That is an example of this lady, the bank teller, being liable for embezzlement. False pretenses. Very straightforward definition. The defendant knowingly, by any false pretense, obtains from another person any chosen action, money, or anything of value with the intent to defraud the other person will be considered a cheat. What the heck does that mean? That means that the defendant intentionally and knowingly obtained something of value from another person and they had the intent to defraud that person. So let me show you an example here on the next slide. An example of this is that let's just say Joe and his wife contacted Wade to improve his home. Wade, however, is a pretend contractor. He's not a true contractor, but he's pretending to be a contractor. And he is accepting customers like Joe and his wife. Wade, a pretend contractor, made an agreement with Joe and his wife to fix their home for $3,000. Wade, the pretend contractor, who doesn't really have the skill to fix the home, takes their money and never fixes the home. That is an example of Wade being liable for false pretenses because he is having the intent to defraud Joe and his wife because he's not a true contractor. He's pretending to be, right? Therefore, he is a cheat under Nevada law, and he will more than likely be liable for this crime. Robbery, one of my favorite theft crimes here. So the straight definition of this, very straightforward. The unlawful taking, physical taking of personal property, let's say a purse, from another person in their immediate presence by means of force or fear. What does that mean? That means that a defendant does not have the authority to take the property from the other person, and that person, the defendant, is in the physical presence, the immediate presence of the victim. And the defendant takes that property from the victim by means of force. Let's say the person punches the person shoots the person in the arm and then takes the property. That's force. Or fear could be a scenario where the defendant uses their gun as a threat, saying, hey, give me your property or else I will shoot you. That is an example of the defendant using fear to successfully take the property from the victim. Under Nevada law, however, the defendant does not need to have the intent to steal at the time that the force was used. So they don't need to have the requisite intent before stealing or even at the time of stealing. Once the defendant actually inflicts that force and then the defendant steals it, that'll be enough. The defendant did not need to have the requisite intent before he or she actually committed the act. That's why, again, robbery is a general intent crime rather than a specific intent crime. So this will allow the prosecution to prosecute defendants who use force for any other purpose than to steal. An example of this, a very straightforward example of this, is that let's say Kenzie punched Sarah in the stomach and then decided to steal her purse. Let's say the robber in this photo here in the black is Kenzie, and the woman holding the purse in the purple is Sarah. Kenzie punches Sarah in the stomach, and then at that moment, after she used that force, she grabs the purse and then runs away. That is a clear example under Nevada law of her being liable for robbery, because again, she took advantage of that scenario of being forceful against Sarah, pushing her in the stomach, and then she made the choice. She had the intent to finally use the force to steal the purse. So that'll be enough under Nevada law to be liable for robbery. Let's dive into burglary. Burglary is the unlawful entering of any dwelling, any house that someone resides in. Let's say you have an apartment where you sleep in, that's where you live, that is the dwelling, okay? Or a vehicle. Let's say that you have a car. It's under your name, it's your car, you drive it to work, grocery store, the gym, whatever. Any unlawful entering of any dwelling, vehicle, or building, let's say a school or Walmart, with the intent to commit grand or petit larceny or any other felony within the vehicle, within the dwelling, or within that building, either by day or nighttime, will be liable for burglary. Okay? So again, the person must have the requisite intent to commit that larceny or felony therein, within the vehicle, the dwelling, or the building. And it must be, again, a situation where it's either by day or night. So it doesn't matter if it's daytime, it doesn't matter if it's nighttime, because as you know, under common law, it's required that burglary happens during the nighttime. However, under Nevada law, it doesn't matter if it happens during the daytime or the nighttime. It can happen either or any time of the day. If the defendant commits these acts, he or she will be liable for burglary. Let's go through a key example. Synoptic. Let's say this guy, the burglar right here, the criminal here, the guy with the mask on is Synoptic. Synoptic has the intent to steal Fick's Rolex watch that is in Fickry's vehicle. Okay? Synoptic he has the desire. He wants to steal the Rolex. He has the requisite intent before he commits the act to take the Rolex that he knows is inside Fick's car, right? Synoptic then breaks in to the vehicle and enters into Fickry's vehicle the following week. That is an example of Synoptic being liable for burglary. So whether or not he successfully steals the watch or not, as long as he had the intent to steal it, as long as he successfully enters the car, breaks into the car, he will be liable for burglary. So that's right. Even if the defendant does not successfully commit the felony, even if the defendant does not successfully commit that larceny, in this case, getting the watch, he or she will still be liable for that crime as long as they have the intent to steal or commit that felony inside the vehicle, inside the building, inside the dwelling, and as long as the defendant actually commits the entering and breaking. That is a situation where the defendant will be liable for burglary under Nevada law. Home invasion. This is a situation that's not taught under modern law, the Model Penal Code, or common law. Okay, this is only in Nevada here. So under Nevada law, home invasion is very, very similar to burglary. However, there's a slight difference here. We'll go through that. So the general definition of home invasion is the forcible entry of a dwelling house of another. So not a building and not a vehicle, but only a dwelling house of another. It could be an apartment, it could be a tent you live in, it could be a house you live in. As long as it's somewhere where an individual sleeps in and where they live, that will count as a dwelling house. Okay. So the defendant must forcibly enter into that dwelling of another person, either by day or night. So it doesn't matter what time of day this occurs. It can happen at 9 a.m., it can happen at midnight. It does not matter. It can happen anytime during the day or night without the consent of the owner or occupant. Because by all means, like sometimes people rent from an apartment, some people rent a house, right? So it's not truly the owner of the house, but they're renting. They're an occupant. They're a lawful occupant of that house. So even if they're an occupant or the owner of the home, if they did not have the consent of the owner or the occupant, and they forcibly enter into the dwelling of another anytime during the day, they will be liable for home invasion under Nevada law. And the key thing here is that the requirement, let's read the second sentence here. This requires entry without permission alone. What does that mean? That means that the defendant does not, basically Nevada requires that the owner or lawful occupant did not give the defendant permission to come inside. And there's no intent requirement for theft, larceny, petit or grand, or felony, which means that the felonious intent or the intent to commit a larceny within the home is not required, as long as they forcibly enter the dwelling without the consent of the owner or lawful occupant. That defendant will be liable for home invasion under Nevada law. So the example of home invasion, let's say Ra noticed gold in Eric's house. He's walking around the street. He looks through the window that happens to be open, and he sees gold in Eric's home. He's like, interesting. That's what Ra says. So I kind of want that gold. Ra then forces his way into the home with this crowbar. As you can see in this photo, see this photo, that man is Ra. That crowbar is Ra's crowbar, and he's trying to get into Eric's home, his dwelling. The moment Ra sticks that crowbar into the home and he leaves that little small crack, as you can see in the picture, that's an home invasion, because he created that entry forcibly with the crowbar, and he entered the home by having the crowbar go inside the home, as you can see in the photo, because the crowbar under the law is technically an extension of his body because he's holding it, and he used it to forcibly enter Eric's dwelling. And in this case, Ra did not have Eric's permission to go inside of Eric's dwelling. That will allow Ra to be liable for home invasion under Nevada law. And like I said earlier, unlike burglary, Nevada does not require Ra to have the requisite intent to steal or commit a felony in the dwelling. As long as he forcibly enters the home, breaks into the home without the permission of the owner or lawful occupant, the defendant will be liable for home invasion under Nevada law. Receiving stolen property. This is the last theft crime that we're going to go through, and we'll finally conclude. So receiving stolen property is very straightforward, actually. Probably one of the more simpler crimes, similar to Petit and grand larceny. So the defendant, for his or her own personal gain, or to prevent the owner from getting the property that belongs to them again, buys the property, possesses the property, or withholds the property from the owner, either knowing it to be stolen or under the circumstances of the situation. The reasonable, prudent person would have known it to be stolen property. And again, you're probably thinking to yourself, what the heck does this mean? I'm going to turn this into English. This means that the defendant who committed this act wanted the property for his or her own personal gain. Okay. And, or the defendant did not want the owner to get the property that belongs to them. And the defendant got this property in the first place by purchasing this property, possessing it, or the defendant, him or herself, is intentionally withholding that property from the owner. And the person, the defendant, knows that the property is stolen, or under the circumstances in this situation, the defendant should have known that the property was actually stolen property. So let's go through an example to make this more clear. The example of receiving stolen property is that, let's say Michael stole an Apple laptop from the Apple store that was worth $1,000. So Michael is a thief, right? In this case, like we said earlier, the $1,200 requirement is for a grand larceny. Anything below that would be petit larceny. So in the first sentence of our example here, Michael is already liable for petit larceny because he stole property from Apple that was worth less than $1,200 because it's worth $1,000. So clearly the property that Michael possesses right now is stolen. Michael then sells that same Apple laptop to Jason for $500. So in a situation like this, if Jason successfully purchases this laptop for $500 and keeps it for himself, this is a situation where Jason should have known that it was stolen because it was kind of too good to be true. A brand new Apple laptop from Apple, still wrapped up in its factory sealed box for $500 when in the market it's worth $1,000. The reasonable and prudent person under Jason's situation should have known that the property is more than likely stolen because it was too good to be true. It was half of the price than what it's worth in the market. So let's say that Michael sold this property to Jason for $900. Then he will more than likely not be liable for this crime. However, because it's a little too good to be true, he should have known. He reasonably should have known that this was stolen property. Therefore, he will more than likely be liable for this crime. Or let's say Michael informed Jason before selling it. He told Jason that, hey, Jason, I stole this from Apple, but I'm going to sell it to you for $500. That's a situation where Jason knew that it was stolen, and Jason still paid to keep the product for himself, to deprive Apple, the Apple store, from ever receiving it ever again because he wants to keep it for himself, right? That is a situation where he knew it was stolen. He wants to deprive the owner of that property, and he will more than likely be liable for this crime of receiving stolen property under Nevada law. The overall conclusion here is that if you have any questions, comment below. And remember, this is for legal educational purposes only for the bar exam, not legal advice. And again, remember, for all these crimes, it is specific intent crimes except for robbery. Robbery is a general intent crime under Nevada law. So again, if you have any questions, let me know. And I guess one more thing to add here is that home invasion does not require the requisite intent to commit a larceny or felony therein. It just requires the forcible entry into a dwelling house only without permission of the owner. Our next video will go through the homicide laws of Nevada, and then we'll get into the criminal procedure, basically the Fourth Amendment activity under Nevada law. Okay, so I'll see you soon, and thank you for watching.